Hello and good morning or good afternoon to wherever you're joining us from. Thank you so much for attending our September 3rd Tuesday webinar. It's the second part of our unemployment webinar series where we're going to cover employer responsibility. My name is Daniel Johnson and I am the Director of Marketing and Customer Experience at MyChart Council. Before we get started, I just wanted to remind everyone that this webinar is being recorded. And on Thursday, you'll receive an email following up from MyHR Council that will include the HRCI code, as well as the webinar recording and any other information that is promised. Today's speaker is Britt Waterman, and Britt, feel free to get us started.
Thanks, Dan. Today's webinar is about the employer responsibility portion of unemployment insurance. Last month we talked about employee eligibility. Today we're talking more about the chargeability, how benefits get charged to employers, why you're paying for unemployment, how you're paying for employment, those types of issues. So the agenda today is kind of a brief history and interaction between federal and state laws, some issues of eligibility, and some monetary qualifications for federal reemployment assistance requirements. So we've got a lot of ground to cover. I'm going to try not to read my slides because, as Dan said, you will be sent the deck on Thursday, so you will be able to read the slides. We've got a lot of ground to cover. I'm going to be going pretty quickly here, so I'm not going to read every word on the screen, but instead kind of read some supporting information. So if that makes it easier for you to keep up, just to let you know. So just a little background, we did go over this last week, but unemployment by the numbers, you can see here the huge jump in the number of workers and the amount paid out over the years since unemployment has been founded, and in the Great Recession, and then the pandemic when things just went crazy. The emergency federal benefits and federal state extended benefits are paid in cases like the Great Recession and COVID. These extended benefits are paid under federal legislation, what happened with the CARES Act. And this is usually paid 50-50 between the state and the feds, and results in additional weeks. So that's kind of what was happening last year when you were wondering about what is the additional $600 and why are employees collecting for longer than they have before. That's a combination of federal and state laws that happens when there are periods of great unemployment like this. So who makes the rules? It's a combination between federal and state. So UI is forward funded. All of the states and the federal government are supposed to build up a trust fund in better times. When the federal trust fund gets big enough, money gets transferred to the states. This has only happened in 8 years since 1954, so not a common occurrence. Alaska, New Jersey, and Pennsylvania are the only states where employees pay in. If your employees say, hey, I'm entitled to this, I work hard, I pay into this, unless you are in Alaska, New Jersey, or in Pennsylvania, they are incorrect. So I'm going to refer to SUTA, which is the State Unemployment Tax Act, and FUTA, which is the Federal Unemployment Tax Act. Those are, SUTA is the law in each state governing unemployment. FUTA is the federal law governing unemployment. So states build up their trust fund. When their trust funds run out, they borrow from the feds. This happened in 2009 and 2020. States need federal dollars to run their programs. So states follow the federal rules. This is why each state doesn't break off and start their own unemployment program and start their own rules. They need the federal government to pay the administrative costs and also to borrow from the federal government when we have a situation like we had last year or back in 2009. So the states want the federal government's money. They want the federal government to pay to administer the program. So the federal government says, look, every state program has to have this law or that law or a law like this or a law like that. And the states say, okay, we'll pass a law like that because we want to continue to receive the funding. So the federal golden rules, just quickly, as far as unemployment insurance, all the money that's withdrawn from the state funds is paid solely to pay unemployment compensation. So your SUTA tax, the money that you pay in, and employee contributions in the 3 states I mentioned cannot be used to bail out another program, another state program, to do administrative overhaul. All administrative costs come from the feds. The feds are not going to help you if you're not following the rules. All the FUTA tax you're paying is going towards administrative costs. All the SUTA tax you're paying is going directly into employees' pockets, though not necessarily dollar for dollar, as we will get into. So to qualify, the federal government sets these 3 requirements to qualify for eligibility for benefits. And everybody has to, every applicant or claimant has to meet these 3 requirements to be eligible. They are the same in all states because they are set out by the feds. And so that's kind of where we start is, you know, in order for you to be chargeable, the person has to be eligible. And in order for the person to be eligible, they have to meet these 3 federal golden rules. So so how do people pay in to unemployment? How do employers pay in? There are 2 types of ways to contribute to the unemployment trust fund. There is contributory and there is reimbursing. Contributory is sometimes called tax paying. Those mean the same thing. So contributory employers pay taxes on their employees' wages every quarter, and that's based on the experience rating. Reimbursing employers pay dollar for dollar when an employee collects benefits, so they are sent a bill. In some states, the only way reimbursing employers are not charged is when they are a base period only. So they may not get charged when they are the most recent employer, but once they come into the base period, they will get charged for their proportionate share of the total liability, regardless of the outcome of the previous separation. So a reimbursing employer, if the employee gets fired, the reimbursing employer will still have to pay their share. It becomes automatically payable when they enter the base period. If claimant is overpaid, the reimbursing employer can only get back what the state can collect. If the state can't collect that overpayment, the reimbursing employer gets nothing from the state. If the state makes an error, the reimbursing employer must pay what the state says or face fines. They can't pay a lesser amount because they dispute state charges. Now, reimbursing employer is something that you have to elect to be reimbursing, and this is something that is an election that's only available to nonprofits, religious organizations, tribal organizations, federal, state, local governments, school district. Those are going to be the types of employers that can elect to be reimbursing employers. Everybody else is going to have to be a contributory employer, and they're not going to have the option to make that decisions. For some contributory employers, there are reasons for separation where the claimant gets paid and your experience rating is not affected. So it's a win-win for both parties. We'll discuss these situations. Reimbursing employers can't benefit from these win-win situations. They are always paying dollar for dollar, regardless of the reason for separation. So we'll kind of cruise through the math here. And like I said, you'll get the slides so you can go back and review this and listen to the presentation again if you like. But taxable wage base, so the taxable wage base is the maximum amount of an employee's income that can be taxed. So when you are paying taxes on employees' wages, you are not paying taxes on their entire wages. You are paying taxes on wages up to a point. It's a maximum threshold. For example, Delaware's SUTA taxable wage base was $16,500 in 2021. So all contributory employers had to pay taxes on an employee's wages until they earn that amount, and then they stop paying taxes. So if you've got an employee who is making $7,000, which is the federal minimum taxable wage base, you're paying taxes on 100% of their wages. If you've got an employee making $70,000, you're paying taxes on 10% of their wages. You're only paying wages up to that wage base. The taxable wage base can vary extremely widely from state to state. Like I said, the lowest under federal law is $7,000. In 3 states, it is $7,000. This includes California, whose taxable wage base has been frozen since 1983, and Florida. I don't know if you ever thought you would see California and Florida together on a list of 3 states in employment law, but they both are staying at the minimum taxable wage base, which is a break for employers. So we think of California as employee friendly, but the big employers who are doing business in California, who have higher paid employees, who are doing a lot of turnover, a lot of the tech employers we're thinking of, they are getting an unemployment tax break to be in California. So that is one of the reasons why California's wage base is so low. It has led, however, to California's UI program being chronically underfunded. They are $21 billion in debt to the federal government right now. In Washington state, the taxable wage base is $56,500. So Washington state is more likely to have a solvent trust fund because you're paying taxes on wages way up to it. The wage base is a lot higher. The original FUTA wage base in the 1930s was $3,000. That would be over $55,000 in current US dollars, but it is stuck at $7,000. So that has not increased at the rate of unemployment benefit payments or inflation or anything. That has been stuck at a very low amount. Employers can get an offset credit if they up to 5.4% if they're paying the feds on time. So that means with that offset credit, FUTA tax for an employee earning $7,000 or more would be just $42 per employee. So if you're paying on time, you're getting the highest credit from the feds, you're paying FUTA tax of $42 for every employee making over $7,000. For an example, another example, under Tennessee UI law, they determine the taxable wage base on December 31st of each year. So Tennessee doesn't know what their taxable wage base is until January 1st, the day it goes into effect. It is based on the trust fund balance. If the trust fund balance is high, the taxable wage base is lower, and vice versa. Experience rating. So the purposes of using the experience rating system is to ensure equitable distribution of the costs of the system among employers who cause unemployment, to encourage employers to stabilize their workforce, and to encourage employers to participate in the system because charges to their accounts directly affect their tax rate. So this is trying to prevent employers from taking kind of a laissez-faire attitude towards unemployment, because with an experience rating system, how much you pay out is going to affect how much you pay in. So it's on you to take responsibility for how much you're paying out and to take measures to reduce the amount of unemployment you're paying out. So, so the FUTA tax takes the 6% tax on the wage base of the first $7,000. Like we said, if a state's UI tax law is approved by the Department of Labor, so like I said, the feds approve the state law, the state's laws have to comply with the federal rules. If a state's UI tax law is approved by the Department of Labor, employers can take 2 credits against their unemployment tax, one for the amount of contributions that they've actually paid into the state trust fund, and an additional credit for the difference between the contributions paid and the amount that would have been paid at the highest rate under the system, up to a cap of 5.4%. So again, if your state complies with the DOL, I don't know currently of any states that do not comply with the DOL, but you can take credits against your FUTA tax for the difference between your contributions and the contributions that would have been paid at the highest rate of the system. That's 1 credit that comes off your FUTA tax. So the calculation period can be reduced to the amount of time that the employer, so the calculation period can be no less than the past 3 years. So the past 3 years is the period, it can be more in some states, but under federal rules, it can be no less than the past 3 years. The calculation period is we look at this period to determine how much you paid out in unemployment, what your total payroll is, and calculate your experience rating based on based on your experience with unemployment. The calculation period can be reduced to the amount of time that you have experience under state law. If you are a company that has been paying out payroll for less than 3 years, states that have less than a year can have a reduced rate of less than the state standard rate. That's something that varies according to state law. You're a new or unrated employer for your first 3 years, and then the experience of those last 3 years kicks in. Some states make new employers their rate 1% across the board for those first 3 years. Some states start that rate out higher based on industry. Something like construction is going to end up having a higher unemployment rate. So that is an industry in which the new rating would start out, the initial rating would start out at a higher rate because it's expected to go to a higher rate after 3 years once you're using the 3-year calculation period. So a construction industry employer may start off right off the bat with a higher rate than employers in other industries. Because it's construction industry is more likely to have layoffs, they're more likely to have experience with unemployment. But the state does set the new employer tax rate range. So they do decide what your experience rating starts out as. It ranges from states that say no tax, you don't have to pay any tax for those first 3 years of the calculation period. Some states will start you out at 20.6%. That's for the top of the box, probably for a construction or a mining employer, maybe an agricultural employer, someone who's got a lot of turnaround. But you can see how much it varies and how much leeway the feds are giving to the states, even though the employers have to use the experience rating system that conforms to the federal employment tax rate. The formula for contributory employers, the actual formula for calculating the tax rate can vary from state to state. So the feds set the guidelines, they don't set the actual tax rate. Types of experience ratings, reserve ratio is the most common. It is contributions that you have paid into the system minus benefits charged divided by your average payroll, and that is your experience rating. That is in most of the states, that is going to be the formula that is used to calculate your experience rating. The balance carried forward every year is going to be the difference between your total contributions and your total benefits paid to workers since you became subject to unemployment tax. And then that's your experience rating. You go to a table, a tax rate table that's set out by your state law, and your rate is assigned according to a schedule of rates based on your experience rating. Second most common type of experience rating, benefit ratio. It's a ratio of benefits charged divided by the ratio of benefits charged, so the amount of benefits paid out divided by your payroll is the index for the rate variation. In that case, with the benefit ratio experience rating, your contributions are not, your tax contributions are not taken into account. And again, your rate then is assigned according to a tax schedule. Benefit wage ratio is only used in 2 states. If you're in one of those 2 states and you have questions about it, we can talk about it, but I don't feel the need to get into a deep explanation. So when you say, is this being charged to me? If you have a former employee collecting unemployment and you say, is this being charged to me? It is not being subtracted in a dollar for dollar way as it would be with a reimbursing employer. If you are a contributory or a tax paying employer, the exact number of benefits received is getting plugged into one of these ratios affecting your experience rating, which is then affecting the amount of taxes that you are paying on your payroll, on your employees' wages. So if you like math, all of the tables are public information, all of the rates. You should get a document every year that tells you your experience rating. You can certainly look at your payroll. The amount of benefits you paid out every year is accessible to you. You can find that information and you can plug all the numbers in and see if you are being charged the correct experience rating. If you're not, you should be able to appeal that. So if you're probably using an accounting or a payroll provider to do this for you. If you are not and you have someone so inclined, you could definitely work it out and see if you are being charged the correct rating. Maximum tax rate. The state legislature puts out the maximum tax rate every year. You can, again, you can calculate your experience rating and find your rate on the table. It varies. So for a small employer, you could hit the max laying off just a couple employees. For a big employer, you wouldn't hit the max until you laid off many more. It's a percentage of your workforce is what's going to determine when you hit the max tax rate. It does not keep going up to 100%. All states have a maximum tax rate. Some states add a surcharge for every year that you hit the maximum tax rate. You could face delinquency charges added to that, of course, if you're not paying on time. So it could increase towards 100% if you're not paying your taxes on time. The states can and do increase the maximum rate and the minimum rate in response to insolvency in the trust fund. So the trust fund gets low, they want to build it back up, they increase the minimum and maximum tax rates. A lot of states experienced insolvency in the trust fund this past year due to COVID, but froze the minimum and maximum tax rate because of the extenuating circumstances. So some states did freeze their wage base and end up with a frozen minimum maximum tax rate currently due to COVID. Some states did not, and the maximum tax rate is and minimum tax rate is going up because of the insolvency due to COVID. Successor employer, we'll talk about, this is when one employer is acquired by another employer. You do not start out as a brand new employer. A transfer of the predecessor's experience rating may occur if it's two pre-existing employers. The rates can be based on combined experience. Any benefits paid by the predecessor are going to now be counted as benefits paid by the successor. And again, this is the Fed setting the guidelines, the states making their own laws within those guidelines. I just want to mention SUTA dumping, which is using this successor employer laws to try and get out of paying unemployment tax. It involves existing businesses purchasing shell companies or registering new corporations and reporting a small payroll each year until you achieve a low minimum rate, and then bringing over large payroll from the previous corporation. So basically setting up a corporation with a small payroll to get a low UI rate, and then bringing your large payroll over from another employer is kind of the most common method of SUTA dumping. You will get caught if you do this. When I mentioned at the beginning of the previous Third Tuesday webinar, I am a former unemployment law judge. I was an unemployment law judge for 8 years. Unemployment is my thing. If you have a question about unemployment law, I only worked in one state. If you have a question about unemployment law in your state, if you are a client, enter a ticket. I can find the answer for you in your state in a, probably in a 2-hour turnaround. If you are not a client and you would like a former unemployment law judge to answer your questions about unemployment, our contact information is on the final slide. Dan, who you heard speaking at the beginning, would be happy to discuss our packages with you, help you sign up as a member and give you access to that advice. But in my experience as an unemployment law judge, we did have one judge dedicated exclusively to people who were trying to get out of paying fines for SUTA dumping, and it was not successful for those employers very much of the time at all. Charges with multiple employers. So most, but all, not all states, but most states have two types of claims. So there's the claim that's attributed to the last or most recent employer, and there's the claim that's associated with the base period employer. So the last employer, the separation from your last employer is going to determine your overall eligibility. When an applicant files for unemployment, they have to say, this is the reason I'm filing for unemployment is because I just separated from X corporation. And the reason I separated from X corporation is I got fired, I quit, I got laid off. And then your department, your agency is going to determine, are they eligible, are they ineligible, going forward based on the terms of that separation. For your every base period employer, so every employer that has employed the individual within the first 4 of the last 5 calendar quarters is potentially chargeable unless you can prove that you should not be charged unless you request relief of charge. So you'll all be, if you're a base period employer or you're a last employer, but you'll all be notified. You'll get a a notice in the mail saying Bob has filed for unemployment, you paid wages to Bob in the base period. If you see it and you think, hey, we fired Bob for stealing $10,000 of copper wire, you do not want to be charged for Bob's benefits. Raise an issue on your account if you know how to do that on your unemployment benefits account, or appeal the notice of base period to request relief of the charges. It will go to, if you do either one, do it immediately. It will go to the proper person, but do one or the other and do it as quickly as possible. Do not let it go, or you will end up being charged a proportionate share for Bob's benefits in most states. So in most states, each base period employer's share is determined by the amount of wages they paid in the base period. If you paid the employee 25% of the total wages in their base period in the first four of the last 5 completed calendar quarters, which is used, the money in that period is used to determine how much the claimant gets paid per week and how much they can get paid total. So if you paid the claimant 25% of the total wages during that set period, then 25% of the benefits paid to them while they are collecting benefits will be counted as benefits paid out that year by you when your experience rating is being computed. So that's how they, so you might not be the last employer, you might not be the most recent person to fire Bob, but if you're in the base period, your share of wages is going to be attributed to you when your experience rating is calculated. Some states base it on last employer and do not involve all of the base period employers, or they require the last employer to cover some benefits before the rest of the base period employers start to kick in. Michigan says the last or most recent employer has to cover the first 100% of the first 2 weeks before it goes to the proportional base period. Georgia makes the most recent employer cover it all. Georgia calculates benefits as the sum of the wages in the high quarter by 26, but Georgia only makes you pay benefits up to the amount of wages you paid your employee. So if you're in Georgia and you have an employee who earned $200,000 in their high quarter, which would qualify them for a large weekly benefit amount and a large maximum benefit amount, and you are the last employer, but they only earned $1,000 with you because they didn't work for you very long, you're not on the hook for the entire period that they would normally be eligible for. If they only earned $1,000 with you, you're only on the hook for benefits up to $1,000. So up till as much as they made with you. So how do I know if I'm being charged? So here's where I tell you the secret to fewer charges on your unemployment account. Better hiring. I can't say it more simply than that. So you may say, we try our best already, but this is truly your best defense. So you need to find out beforehand whether the person can do the job, whether they can keep up. You can't screen out for disability. If someone has a disability, you have to make reasonable accommodations. But you find out beforehand if they're going to fit with your company culture. Bring back the team takes the applicant to lunch interview to get a sense of any issues that may come up. If you're in casual conversation with the whole team at lunch and it leads to bragging about partying, this person might not be the most reliable employee, or they might not be the best fit with your company culture. If they tell you they don't have a car and they're trying to piece together rides and it's not very successful, again, maybe not the best hire. You can't screen out based on protected class status, obviously. If they tell you their age or they're discussing, activities that would point to an older worker, you can't screen that out. Marital status and familial status in a lot of states, sexual orientation, you can't. You can do the, the lunch interview, but you can't screen out for those reasons. That's obviously illegal. But you can get a good feel of this person's attitude about work with using better interview tactics. And your UI charges inevitably start with your job postings. So that's the start of your road to being charged. I can't put it any more plainly than that. So and also one other thing, last month we did talk, or at our last webinar, we did talk about how former employees, claimants must be able to work, available to work, and actively seeking work. If they're not getting benefits for a few weeks because they're in vacation, on vacation, or in school in some states, or they're just not looking for a job, that's fewer weeks to add to your charges if they're not eligible those weeks. So if you know they're not able to work, available to work, or actively seeking work, you know they went to Mexico for a week, you know they're bragging to their friends that they're not doing anything to look for a job because they're going to collect unemployment. I mean, you have your suspicions, you have your evidence on Facebook, whatever, call the department and report this person. They'll look into it. Call your agency and say, I have evidence that this person is not available to work. They're in school. Like I said, in some states, they are allowed to be in school under some circumstances. But if you have evidence that, call them on their job search, and your state agency is going to contact them and say, produce evidence of your job search over the last however many weeks you've been collecting unemployment. So if you don't do this falsely, but if you have a reason to believe that this is the case, raise an issue on your account, contact your agency. Don't let 1 week of benefits count towards your experience rating if that week doesn't have to. Layoffs, terminations, discharges, you will always be charged for a layoff or a reduction in force. There is no way to get out of that. Terminations and discharges, some states have a list in their statute of disqualifying offenses. If your employee did something on that list, good for you. You will probably not be charged. If your employee did not do something on the list, it's a little harder to make your case. Some states use language like wanton, willful, intentional. Some states include negligence. Some states say if it was negligent, it's not disqualifying. There is, in every state, there is a person in your state's agency. This is one person who gets your questionnaire and gets your former employee's questionnaire. And they are taking what they have been taught about the law in your state, and they are looking at these two questionnaires, and they are deciding whether or not this person is going to be eligible and whether or not you are going to be charged. The more documentation you send in when you send in your questionnaire, the more that one person has to look at, and the easier it is for them to make their decision. The more that person can see that weighs towards misconduct, the better your chances. In most cases, the person is looking at the information, looking at what the employee did to separate from the employment. Sometimes they're looking at what you did. Sometimes they're looking at what the employee is saying about you, and they're thinking about whether or not you should have to pay for their benefits. I mean, this is one person, and they're forming an opinion about you just as they're forming an opinion about the employee. And this may not be entirely fair, but this is what's going on when you are sending in those questionnaires and sending in your documentation. So don't come off as vindictive or hateful towards your former employee. Just send in the facts so this person can make a decision. Some states allow employers who have established a probationary period to discharge employees for no misconduct during that period and not get charged for this. This is not every state. This is something I hear commonly. People think this is every state. It is not. Your probationary period may have no legal effect. You may get charged for discharging someone who is not a good fit. find out if this applies in your state. If it doesn't, you're out of luck. Voluntary separations, good cause examples, harassment, discrimination, dangerous working conditions, you're going to get charged. Some states require them to complain to you and to give you a chance to fix it before they would become eligible and you would get charged. So make sure to have procedures for documenting employee complaints. If you don't show anything from this employee, and your supervisor and your HR person can say, she never came to us, we never heard anything about this, you may not be charged, even if the employee can show that harassment occurred. In states that require the employee to complain first to be eligible, you would not be charged if you could prove that the employee never gave you a chance to fix it. So what about those win-wins that we talked about earlier, where the employee gets paid and you don't get charged? So these are issues where there is a voluntary separation due to something like illness, caring for an ill family member. In some states, lack of childcare. More than half of states have a domestic violence exception where the applicant would get paid and the employer would not be charged. 47 states have a military spouse exception. That's going to result in payment for the claimant and no charge for you with those military spouse exceptions. Some 19 states have following any spouse to a new job. Some states, if the employee gets a better job and it ends up not working out, that's not their fault and that's not your fault. Neither one of you gets penalized for that. Some states let the employee have a trial period, and if they quit within the first 30 days and can show the job was unsuitable, they get paid and you don't get charged. This depends on the state. In almost every state during COVID, most states suspended charges for anyone who quit due to COVID, even if an employer would normally be charged. Charges for claims due to COVID were suspended in a lot of states. What happens when you have to fire somebody after they've given notice? This varies from state to state. Some say the person still quit as of the notice date. You don't get charged because they quit. Some say there was still work to be done and you were the moving party. You discharged them for giving quit notice, which is not misconduct. You're getting charged. Ask counsel. Someone gives notice and you're wondering if you're gonna get charged if you let them go early. Ask your employment law counsel, because it's going to depend on state to state. Documentation, as always, like I said, keep notes of employee complaints, ask for a resignation letter. If you can get it, documentation always helps. Part-time based on full-time, this is not in every state, but I did want to add this because this is in some states. So in some states, you will not be charged if you are a base period employer. So again, you employed this person during that first 4 of the last 5 calendar quarters. Some states do, you can use an alternate base period, which is the last 4 completed calendar quarters. I mentioned the standard base period, but if you're actually trying to work out whether you're in the base period or not, keep in mind that your state may use an alternate base period. So whether you're in or you're out is going to depend on which one your state is using. So it's not, so me saying first 4 of the last 5 completed is not always a hard, fast rule. That may change. But in some states, if you are a base period employer and you have an employee who has a full-time job, and they are also working part-time for you, and they separate from their full-time job and they establish an unemployment benefit account, and they were working part-time for you in the base period, and they continue to work part-time for you now that they have established a benefit account after separating from their full-time job, even though you're in the base period, you're not going to get charged. This is only in some states. This is not in every state. but states don't want you to be notified that you've got wages in the base period of someone who just filed and panic and try to get relief of charges by attempting a disqualifying separation. So they don't want you to have this part-time employee who's been working for you, who's still working the same number of hours and has been for years. They don't want you to see that you're in the base period and freak out and try to trump up some misconduct to try and terminate this employee to get yourself out of charges in the base period. They want to encourage you to continue to provide part-time work to these employees while they collect benefits. And if they're working part-time, their benefits are lower. It benefits everybody, but you do have to provide the same number of hours in the benefit year. So while they're collecting benefits, you have to provide the same number of hours as you did in the base period. Otherwise, it's a reduction in hours, just like it would be for any employee whose hours you cut. They could collect for those reduced hours and you would get charged. They could also quit working for you with good cause because you cut their hours and you would be charged. So again, not every state, but you would want to know if it's your state. Staffing agencies, this is a whole new ball of wax with staffing agencies. This is chargeability for you is going to be a whole new issue. In some states, so the end of an assignment, and this is pretty much universal in every state, the end of an assignment, client says we don't need any more workers, or this project is finished, or we don't need this person to come back. The end of an assignment is a termination. It is a termination from employment. It counts as a termination for the purpose of unemployment. So then we have some questions. So in some states, it's written in the statute that it's a termination. The reason for this is because the states don't want to punish an employee for taking a temporary job while they're unemployed. However, staffing agencies have advocates too. And some states have laws that state that failure to request a new assignment after an end of an assignment turns the separation into a voluntary quit. The claimant's disqualified, the employer is not charged. So that it is a termination, but it puts it back on the applicant. If the applicant doesn't call in, now it's a quit. And now you, the staffing agency, are not charged. Some states have laws that if the staffing agency calls you and offers you another assignment and you turn it down, turns it into a voluntary quit. This is important because it's different than refusal of an offer of employment. Generally, a refusal of an offer of employment makes a claimant ineligible for a set number of weeks, and then their eligibility starts over again, and it doesn't relieve you of charges, except those few weeks don't count. If an employee separates from you and it's considered a quit, you're off the hook, you're not charged for that employee. So if turning down an offer retroactively turns the separation into a voluntary quit, you're not charged for future benefits. And so if your state has that law, that's something you want to be aware of. If there is a day limit, then you're going to want to be calling that person within 5 days or 3 days, whatever the statute says, and offering them a new assignment. Some states make you provide employees with a notice. The notice is defined by statute, notifying the employee of this requirement, the requirement to call in or to take a new assignment that is offered, or they will be considered to have quit and their UI benefits could be affected. If your state requires this notice, make sure your notice complies with the statute. And again, if you are a client of us, I can provide you with a notice that complies with your statute. If you're not a client, and if this is something you're interested in, this is one of the things that we offer. It would be a notice that is compliant with the statute. I have, as an unemployment law judge, I have tossed these notices for non-compliance based on a few words in the notice. It is very strict. They have to follow the statute. And you must give them before the beginning of every assignment. And again, documentation, get an employee signature, or you are going to lose. Postponement versus cancellation, talked about this a little bit with the refusal versus the separation ineligibility. Eligibility and chargeability is based on the separation from employment. If an employee is disqualified, they usually have their benefits postponed. If someone's separated because of misconduct or they quit with no good reason, they can't get benefits until they work in subsequent employment and make X times their benefit amount or make a certain amount of money in subsequent employment. And then they become eligible again. There is a way, if you are a base period employer, to have your wage credits, so the money they earn from working with you, to have them completely wiped from the base period. That is only for misconduct in connection with the work. Some states call it aggravated misconduct. Some states call it gross misconduct. If you terminated someone for a felony or a gross misdemeanor committed at work related to a work, theft, embezzlement, fraud, healthcare providers, misdirecting drugs, you should contact the department. If you get a determination that says termination, misconduct, you should raise an issue and say, actually, this should be gross misconduct or aggravated misconduct. You should have those wage credits completely wiped out of there, because you don't want them to satisfy the requirements to earn more and be able to build a new account based on the wages you paid them. Even if you're not being charged, you don't want them to use your wages to get a higher benefit amount when they committed a felony at your job. So that's just something to keep in mind. Appeals, read your mail and your email. Make sure your contact information is up to date. Open and read everything they send you on the date that it is sent to you. Get familiar with your online system. Check it regularly. One of the first things you should do when you get a new HR person is change the contact information with UI and teach them to use the system. Again, they will send out the notice showing that the claimant has filed and a notice showing their wage credits. Check it against your payroll. You don't want to pay over a dime over your proportional share. If the notice doesn't match your payroll, appeal. If they put layoff as a reason for separation, you might not get anything in the mail, so be sure to keep checking former employees online. If they are collecting, an eligibility decision was made, and if they're getting paid, you're getting charged. So make sure you're checking that so you can appeal immediately. Do not assume everything is done after you respond to the questionnaire. You should get an eligibility determination in the mail. Again, stay on top of your online account. If you see a former employee get paid, you might be being charged. You need to look into that. You need to appeal right away. In some states, there is no good cause exception to filing a late appeal. 0, none. If you are 10 minutes past midnight, you are out of luck. Even if you didn't get the determination in the mail until that day, appeal immediately. Worry about documentation and witnesses after you file an appeal. Documentation, now is when you put those emails, text messages, notes of conversation, everything you are saving to send in to support your position. No need to send the entire personnel file or a warning for some one-off, totally unrelated conduct from years ago that went nowhere. Do not make the judge or the hearing officer read more than they have to. Only sending things relevant. You can release documents to an administrative agency, so you're not violating ADA to send in something with medical info. Side note, HIPAA does not apply to you unless you are a physician and you treated the employee or you are a health insurance company. But if you're not a health insurance clearinghouse, health insurance company, or healthcare provider, don't worry about HIPAA. So you can send in everything you have that is relevant. Everything that supports your argument should be included. Send your documentation in immediately. The judge or the hearing officer is going to need a copy of everything you send. They will need to make a copy and send it to the applicant, your former employee. They will get a copy of everything. If everybody doesn't have everything, it might not come in, it might not be included. So give the agency enough time to make copies for everyone and send copies to everyone. If you send it in too late and the judge doesn't get a copy, you're out of luck. It doesn't get used. Don't have a witness repeat the same thing as another witness. Do not drag things out longer than they need to be. Do not put the CEO of your company on the phone just to argue about how he doesn't want to pay for UI if he did not witness any of the conduct at issue or make the decision to terminate. Don't put anyone on the phone who does not have firsthand knowledge of what happened or who did not make the decision to terminate. Nobody wants to pay for UI. The judge does not want to hear why you don't want to. The judge is evaluating your credibility, so it helps to have someone on the hearing who saw the same thing that someone else wrote about in a witness statement and have the two match up. But if you have repetitive testimony, it's going to backfire on you. It's going to look like you have no substantive evidence, and you're going to be wasting the judge's time. You and the claimant should have the right to cross-examine each other or ask each other questions. Think about this before the hearing and prepare questions. Do not do what you've seen on Law and Order and make all of your questions accusations with a yes or no on the end. Don't make a question, you called in sick on December 13th, but you really went to a party, didn't you? That's a statement with a yes or no at the end. That's not the kind of question you should be asking. Show your evidence that he went to a party on December 13th because he's just going to deny it. There's no point in asking those questions. Go over what the claimant said in his questionnaire. You'll get a copy of that. You'll get a copy of his appeal statement if he's the one who appealed. Go over what he's written down and come up with questions that will make him account for things that he tried to hide or tried to gloss over in the information that he provided to the agency. Try to bring that out in the open. These are the questions you should be asking, and you should be prepared with them before the hearing. You'll probably be allowed to make an opening or closing or a summary statement. Prepare something brief and to the point. Summarize your reasons why the claimant should be disqualified under the law. Again, check with counsel. You do not need to be represented at the hearing, but you can have counsel go through the questions or the summary statement with you and check to see if that's going to comply with the law. Refer to the judge or the hearing officer as judge, name, or your honor. Sir and ma'am are kind of falling out of fashion. They're better than nothing. If you think you can use it without misgendering the judge, do not call them by their first name. Do not speak until you are asked to speak. Do not try to help another witness. Do not try to help them remember something or fill in a detail. Do not yell, he's lying, or try to correct or contradict anything else the claimant says, no matter how wild or offensive something your former employee says. Wait until it is your turn and address it then. Do not talk over someone else. These hearings are generally done voice over internet or over Zoom, and if two people are talking at the same time, the judge cannot hear either of you. Read the law or have counsel advise you so you know what the law is and you know what you are arguing. Not just he was a bad employee, but our statute says an employee who was terminated for wanton willful conduct is ineligible, and this is why their conduct falls into that. So your state agency's website may have a simplified explanation of what misconduct is and what disqualifying conduct is under the law. Check your state agency's website. They may have all that information laid out for you, or have the experienced HR and employment law attorneys at My HR Counsel do it for you. We would be happy to do it. You don't need an attorney to be in the hearing, and oftentimes the attorney can only make the proceedings more complicated. If the claimant has an attorney, do not be intimidated by this. You know your facts, you know why your facts make them ineligible. Just stick to it. If the attorney asks a low blow or a personal or irrelevant question, it is okay to ask the hearing officer or the judge, do I need to answer that? Is that relevant? You don't need to answer a personal question that has nothing to do with the separation. In conclusion, do the math. Like I said, check the letter you get every year with your experience rating. Check the letters you get with the base period wages of everyone who applies. Make sure everything's matching up and you're not paying a dime more than you should be. Better hiring reduces the amount you pay out, and that's just something that you're going to have to work on the front end to save money on the back end. Know the law for filling out the questionnaire when someone separates. Know the law when you have appeals. Know the law about how your tax rate should be determined. Familiarize yourself with as much of the law as you can, because the more you know, the more control you have over how much you're being required to pay in. Document. You should be documenting anyways. You never know when someone's going to call a plaintiff's attorney or the EEOC, no matter how baseless their claim is. But you may need it for unemployment, if anything. Have the warnings, the witness statements, the notes from investigation to back up what you send with the questionnaire. And so that concludes what I have today. And I apologize if that was a little rushed, but like Dan said, you will be getting the slides and the recording of the presentation. So, and I don't have any questions. So I will just remind everyone, if you are our client, any question on unemployment, please enter a ticket. If you're looking for help with a document, advice on a hearing, you're drafting a policy, anything like that, please ask us any question, let us know, open a ticket, ask for a document. I think some of these documents are in our Solutions Center. They're already there, you can find them. If you are not our client, please go to myhrcounsel.com and read about our packages, what we offer. I am just one of a number of experienced HR and employment law attorneys who are happy to assist you with anything HR and employment law related for a per employee per month fee. It is not like a law firm where the meter starts ticking when you pick up the phone. Please go to myhrcounsel.com and learn more about what we can do to meet your HR and employment law needs. So thank you all for participating in the program today, and I hope you all have a wonderful afternoon.